sit.
Please take your seats.
Yes, Mrs. Registrar.
Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of Barbados. Hearing of application in CCJ Appeal BBCV number 5 of 2019 between Sigma Construction Inc., Birch Development Limited, Cedar Development Limited, Chestnut Development Limited, Conifer Development Limited, Hornbeam Development Limited, Sycamore Common Services Limited, Willow Development Limited, Ram Holdings Limited, Copting, Singer, and Friedland Limited. Your panel today comprise Honorable Mr. Justice Witt, Mr. Justice Anderson, Mr. Justice Barrow, Mr. Justice Burgess, and Mr. Justice Jamadar. Please state your appearances for the court.
Thank you.
May it please the court.
We just need to know who appears.
May it please the court, Ivan Alert, on behalf of Ram Holdings Limited, the 8th defendant.
May it please your honors. My name is Garth Patterson. I appear for the 9th respondent. With me are Bartlett Morgan and Ms. Taylor Lorraine.
Thank you.
Your honors, I wonder if we may remain seated when we present.
We would prefer if you remain seated.
Much obliged.
That's easier for everybody. Thank you very much. This is a hearing of an application for special leave. It was not ordered that this will be treated as the appeal. It is, of course, a matter of a procedural issue. And it has to be understood in that way. We have said in the order that you would have no more than 60 minutes, but having read all the submissions, we do think that you should be able to use less time than that. If you can't tell it in 15 minutes, you cannot tell it in 60 minutes. Now, I won't limit that 15 minutes with strict rigor, but the idea is that you have to have a very good case for us to give special leave, because basically you're done unless you have very convincing arguments that this case should go back before the Court of Appeal to really hear that case and the merits. That is how we understand it. So, having that said, Sir Richard, may I invite you, Mr. Weeks?
Your Honor, before Sir Richard begins, you would have noticed that we had given notice of our intention to make an in limine objection to the application before the court. We did file in the case management checklist indication of our intention to make an in limine objection. That's at page 739 of the record. Our affidavit of Baron Armand, which was filed in opposition, also indicated the procedural issue, the procedural point that we wanted to make. And our submissions indeed address those procedural arguments. I don't know if Your Honor would
Was that the
Chairman
point that the
Church.
decision given by the Court of Appeal was given earlier in an oral manner?
Well, it's 2 points, really. When you look at the language of the application that's before the court, it speaks to special leave to file a notice of appeal against the decision of the Court of Appeal made on the 13th of June, dismissing its appeal to the Court of Appeal.
Okay.
And we took the point that, as worded, the application before the court proceeds on a very false premise, namely that the Court of Appeal dismissed the appeal, because that premise assumed that there was an appeal that was extant before the Court of Appeal, which was capable of being dismissed. Your Lordships will be aware that, in fact, the question whether or not the notice of appeal that had been filed was challenged, whether that notice of appeal was properly filed, was the subject of the Court of Appeal ruling. And the Court of Appeal ruled that the notice of appeal was a nullity because leave to appeal was required.
So they didn't hear the appeal.
First point,
So they didn't
there was
hear-
no appeal.
There was no appeal.
There was no appeal. They didn't hear it. There was no appeal. That's the
There
point.
was no appeal.
Yeah. And the
That's
sec-
point one. The second point is that when you look at the grounds, the proposed grounds of appeal before this court, that's appended to that's set out in the notice of application for special leave. Ground one says, the proposed grounds of appeal are, 2.1, that the Court of Appeal erred in holding that the applicant, pursuant to Section 54(3) of the Supreme Court of Judicature Act, required the leave of the Court of Appeal to file a notice of appeal against the decision of Worrell J on the basis that an appeal from an order/judgment dismissing a claimant's claim pursuant to Part 15 of the Supreme Court rules is an interlocutory order. What they're saying there is that the appeal that they propose to make before this court is an appeal against the decision, the ruling of the court, that leave was required and that consequentially the notice of appeal that was filed was a nullity. The problem that we have with that, of course, is that that appeal, that application, if that is the grounds of appeal, the decision to which that ground relates was made 2.5 years before the filing of this application. 2.5 years ago, on March 28, 2017. So we're saying that we're not quite sure what this application is. This application on its face says it is seeking special leave to appeal against the dismissal of its appeal. But when you look at the proposed grounds of appeal, the first ground says, well, we're appealing against the decision or ruling that leave to appeal was required, which was made 2.5 years before, 2 years and 4 months before this application was filed.
Okay. So those are the 2 points in limine.
Those are the 2 points in essence.
Yes.
We had filed more ample submissions setting out why we say that those are non-starters.
Okay.
And counsel for the applicant did file submissions in response where they're saying, well, never mind what we said, you know what we mean. But when you look in their submissions, that the reliefs that they're claiming, is instructive. And if
Okay.
you look at
Mr. Patterson, huh?
Yes.
executives,
We have noted the 2 points that you made. Let's not make it more complicated than it is. We have heard it. We will read the reaction, and we will now hear Sir Richard, what he has to say on those points and on the submissions that he wants to make for this application. So, Sir Richard, please come forward.
I wish to indicate at the very outset, sir, that my learned junior, Mr. Brian Weeks, will present on behalf of the intended appellant in this matter, Sigma.
Okay.
Before giving way to him, though, sir, may I be permitted to comment on the attempt last evening around 5 o'clock? We got notice of 10 cases, 200 pages, which was sent by counsel for the 9th responding to this matter. We were not able to download them, to see them actually, and to that extent, we are not in a position to rely on any of those cases which were filed yesterday, or attempt was made so to do. I don't know whether the court itself not hold of them, but I just thought it would indicate that we are in the dark in relation to those cases because we were never able to download them, print download them. But at 5 o'clock, we were able to see that an attempt was being made to send it.
Okay.
We were never received, sir.
So Richard, if it's of any comfort to you, can I say that I find myself in a similar position, so you're not alone.
It will not surprise you to know that I think everybody is in the same position.
Well, I would just add one further comment before we get on, and that is that this court must really insist that deadlines be honored. In the nature of life, there will be from time to time good and substantial reasons why we cannot honor timelines. Sometimes the sickness of the principal counsel, or the known counsel, all sorts of situations can arise. But generally, the timeline should be honored, and we should insist on that.
Yes.
But I'm glad to know that I'm not at any disadvantage.
No.
Members of the court themselves are particular disadvantage. I now give way to Mr. Weeks.
Thank you. Yes, Mr. Weeks. So the idea is highlight the strongest points that you have.
Indeed, Your Honours.
Sorry, in relation to the application for leave, not in relation to the appeal.
Yes, William.
Okay.
As your Honours are well aware, obviously, this is an application for special leave. The jurisprudence of this court is really quite clear. We must present an argument to this court which is quite compelling to convince this court to interfere with the findings of the courts below. That is uncontroversial, and that is what I will attempt to do by way of this application. This application comes from a background of a claim which was filed, as your Honours would be aware, having, I'm sure, read the documents carefully, where Sigma obtained a judgment against the trees, the first six, and for ease of convenience, we call them the trees. And we also obtained a charging order over certain properties owned by the trees in Maynard, St. Peter, and Barbados.
The trees are 6, huh?
The trees are six trees, almost a forest. And Sigma was hired to do a construction contract to build a series of townhouses, condominiums, what have you. And the revenue, or the money that was to be used to construct that, came, as we understood it at the material time, from this loan that was made from KSF, Copting, Singer and Freelander, to the trees, and so on. For whatever reason, the contract and that project failed, which led to Sigma filing their claim, obtaining their judgment, getting a charging order, and in an attempt to execute that judgment, certain information came into their possession, which led to them filing initially a claim in the High Court of Barbados, which alleged, among other things, that there had been some form of a conspiracy afoot between KSF, Ram Holdings, and the trees, where essentially the trees had managed to pay off half, essentially, of the debt owed to the KSF, and instead, basically, of having a release, what they've succeeded in doing is to have an assignment of that remaining debt to a third entity, namely Ram Holdings. And the information which came into our possession at the material time was that they were basically the same underlying beneficial ownership. And the aim of that exercise at the material time was to defeat the charging order which Sigma had obtained over the same property, and therefore would be in a position to safeguard itself from enforcement of that judgment.
Mr. Weeks, would
Yes.
it help if I were to say to you that what I thought was the background was that the Court of Appeal decided that it was an interlocutory appeal which needed leave, and decided that the Court of Appeal would not extend time for filing an application for leave to appeal out of time?
Yes, but
That's what the case is about.
it is,
Yeah.
but I wanted to just set a factual background so that
And
everything could be.
I understand what you're doing, and I think I'm trying to tell you that in relation to those two propositions, I mean, all of this thing about the $10 million sold for $5 million, etc., I'm just curious as to, in fact, I'm not curious. I'm not curious as to what that has to do with this at all, because right now it seems to me that it doesn't have anything to do with those two discrete questions.
Well, the discrete question that the Court of Appeal was confronted with, if we go zero in on that issue,
Right.
the Court of Appeal found itself in a position where a notice of appeal against the decision of World J had been filed, and a point in limine taken by my learned friend, Mr. Patterson, in the Court of Appeal, that in his view, that this was an interlocutory order which required leave. We litigated that issue before the Court of Appeal.
I think the formulation I put to you takes you past that, you know.
Well,
We are at the point where we all know very clearly that the Court of Appeal said, after all of that, objections taken, amendment, etc., the Court of Appeal said it was an interlocutory appeal and leave was needed.
Yes.
So focus on that.
Right. So there are two issues. One, as I understand what your Honor is prompting me towards, is whether or not the Court of Appeal was correct in that assessment.
Right.
And two, if they were correct in assessing it as interlocutory, whether its analysis of the strength or weakness of the case in its analysis as to whether to grant leave to file out of time, they were correct in that assessment.
Okay.
So there are two different discrete issues which are before this court.
Right.
Now, we have filed very detailed submissions before this court as to why we believe that the court erred in finding that it was, in fact, an interlocutory order as opposed to a final order.
Right.
Now, the issue there is, my learned friends have taken the position that if that finding, if we wanted this court to entertain an objection or to quarrel with that finding of the Court of Appeal, we ought to have appealed that finding at that time. And that therefore, attempting to raise that issue now, we, as if I understand his submission, is that we are out of time to ask this court to entertain an application to disturb that finding of the Court of Appeal. Now, the application which we filed in the CCJ, if one looks at how it is worded, we actually appealed the finding of the Court of Appeal issued on the 13th day of June 2018, and 2019, I beg your pardon, Your Honours, in which the Chief Justice was very clear to say what application was before the court, and dealt quite substantively with the issues which were litigated before the court, disagreed with our position, and said that on the merits of the case, the appeal didn't have much chance of success, and therefore they would not grant leave to file an application for leave out of time, and that would be the end of that.
Just for my edification, Mr. Patterson made a reference to a decision given in March 28th, 2017.
Yes.
Can you say to us what that decision was?
That decision was after the Court of Appeal had heard full argument on Mr. Patterson's point in limine as to the point of interlocutory final. The court heard us,
Yes.
reserved its decision on that issue, came back, said, well, we've considered our arguments, Mr. Weeks. We're not convinced by them. We think it's an interlocutory matter, but we'll hear you on your application because what I had done is I'd filed...
Did they make a decision on the 28th of March, 2017?
They did. What they did then was to proceed to hear our arguments.
Sorry.
What was the decision?
What was
The decision was that, in their opinion, the Court of Appeal's opinion,
Yes.
an appeal from a decision of the High Court predicated on Part 15 or Part 26,
Summary judgment?
summary judgment or striking out,
Right.
because they're predicated in both in the application, which was before World J,
Yes.
that in their opinion, that type of a decision was really interlocutory,
Okay.
and that leave was needed.
Was needed. Okay, so
correct.
I'm following you now. So is Mr. Patterson wrong in saying that on March 28, 2017, the Court of Appeal gave a decision that the application related to an interlocutory order?
Well, yes,
He's wrong?
No, he is correct.
He's correct.
When he says that that decision was made on that day.
Yes, so why is his follow-up not also correct, that you ought to have appealed that decision within a particular time?
Well, that decision, and perhaps we ought to have, with hindsight, filed an application on that particular issue at that time. But what actually happened, as a matter of fact, on that day, was that the court then entertained argument on the application which I had also filed, which was that in the event that the court found...
That's a different matter altogether.
Indeed. So what I'm saying is that, whether correctly or incorrectly, the intended appellant here has treated the entire issue globally. The issue as to whether we're right or we're wrong on that is, but in any event, we say that even if...
But you're gliding over that is a very important point.
Well, only insofar, Your Honor, if the quarrel that Mr. Patterson has with the way that our application is worded, the actual application before this court is worded. He says, as I understand it, that we make reference, and it is true to the decision dismissing the appeal before the High Court. But what is also very evident, if one looks at facially at our application, it says that we are seeking the special leave of this court against the decision of the Court of Appeal on the 13th day of June 2019, which is the material contained in that judgment.
Right, so that decision basically was that the Court of Appeal would not grant you the leave necessary for you to file your notice of appeal.
Indeed.
And the reason for that, said the Court of Appeal, was that it was not in the interest of justice.
Indeed,
so to
it
do.
was not meritorious.
So then, are you prepared at this point to abandon the first ground, which is to say that this was an interlocutory the decision was that it was an interlocutory order. Are you willing to concede now that it was, in fact, either a final order or that you did not appeal that decision in time, so that the only thing we have to focus on is whether the Court of Appeal was right to say it was not in the interest of
Meritorious,
justice
yes.
for you to continue?
So, Your Honor, the issue framed in that way, I have two responses. One, I have no choice but to concede that there was a decision in March of 2017.
I think we'll get on much more quickly if we just came to the point. The point is,
Well,
are you willing to concede then that the only ground that you're bringing before us has to do whether the Court of Appeal was right in saying we're not going to give you leave because it's not in the interest of justice so to do?
I would wish to just be heard on the first issues raised by Your Honor in relation to the interlocutory final issue. For this reason, and this is why I began by saying that I would have no choice but to concede that a decision had been made in March, and that therefore, if this court...
But do we have any jurisdiction to hear you on the point?
Well, no, because I would now have to file or seek this court's indulgence, and I wouldn't hold out much hope, I don't think.
Well, have you made the application?
No, I have not, Your Honor.
So we can't hear you until you make the application, Mr. Weeks.
But I'm not finished quite yet, Your Honor, on that particular line of reasoning, and it is for this reason. The Caribbean Court of Justice Act itself that forms this court, and this court's jurisdiction and its judgments on interlocutory matters says that only final judgments come to this court by way of appeals as of right.
Yeah.
So there is a question even for this court as to whether or not certain types of judgments, like Part 15s and Part 26 striking outs, are in fact final or interlocutory, because it affects this court's jurisdiction as well. So you have the CPR set of rules, and you have the CPR...
But Mr. Weeks, sorry. I think the question which my brother Anderson is raising with you, is that relevant in the matter before us? Of course, as a general matter, your observation perhaps is correct. But does it arise in the matter before us, given the fact that a decision was given sometime in 20...
As I said, Your Honor, I am prepared to move on, frankly.
So why don't you...
All I'm saying, Your Honor, I have to try to do justice to my client's case and to make sure
But also respecting the court's time and not pursuing matters which are not properly before the court.
Well, Your Honor, you see, this is, I'm not prepared necessarily to concede that this issue of interlocutory final is not something, or not an issue, which this court, even if in some form of obita or guidance, can give, because it is very, very important under the CPR, because judges take different views. And as a matter of fact, just by way of reference,
Mr. Weeks, the chairman, before you started, suggested that 15 minutes would have been appropriate. Now, do you want to use those 15 minutes on the point that you're on at the moment?
The chairman also said he would not limit us to 15 minutes.
I wouldn't be very rigorous, but
yes,
nevertheless,
nevertheless. All I'm trying to get across to the court is that in the fact scenario of this case, this is not the only matter that has engaged the attention of this court involving these issues in a different tangential way. And there was another case where the High Court judge made a different decision on the exact same application, and it was dealt with differently. So all I'm saying is that there needs to be some sort of a secure, precise method of dealing with these types of issues. But I will move on to what I think is actually the meat of the matter, which is, we say that both courts below, the Court of Appeal, in reviewing the decision of World J, fell into very, very serious errors of law.
But was it indeed reviewing any decision of World J in the matter which in the issue that you've identified as the issue.
I'm not following your
Sorry,
logic.
hadn't you approached the court by way of application, saying to the court that if, as had been decided, this is an interlocutory matter, and we need we need to file leave to the court.
Yes.
We would wish you to exercise your discretion
Yes.
under 62.12.
Yes, Your Honor.
Okay, to give us leave, to extend the time.
Indeed.
For us to apply to the court for leave.
Yes.
To appeal.
Yes, ma'am.
And that's the matter which is before us, isn't it?
Exactly. So what I'm saying is that in their analysis,
But
So
Mr.
if-
Weeks, that's not a matter that the first instance judge had to apply his mind to. What our brother is saying is that the interest of, because you were out of time, the interest of justice point was a point only raised to be considered by the Court of Appeal. It was not a point that the first instance judge, it did not arise before him. It was not a point he had to consider, and so it cannot form the basis of an appeal to this court in relation to the refusal of leave. In other words, the Court of Appeal, you want to say, erred, because on the interest of justice requirement, on the extension of time aspect of the application, they were wrong. Isn't that what you want to say to us?
that is exactly what we're saying to the court.
So it has nothing to do with Warrell J. It has to do with the Court of Appeal.
Well, Your Honor,
That's all that our brother is saying.
yes. But
You are saying.
a part of that analysis,
When they were dealing with the interest of justice.
Justice, you have to look at the
They
case.
dealt with some of the reasons given by Worrell.
that's exactly the point. So in analyzing whether or not it was within the interest of justice to give us the leave, the permission to pursue our appeal in the normal way that it would otherwise have been possible, we say that in the analysis, or a part of the analysis as it relates to the interest of justice point, in reviewing the law and the relevant issues which were relevant on the substantive matter, we say the Court of Appeal erred in its application and understanding the relevant principles.
Is it enough to say that it erred? Wasn't the Court of Appeal dealing with the exercise of a discretion?
Yes,
By, I'm not talking about the 62.1 discretion in the Court of Appeal, I'm talking about the discretion in Mr. Justice Worrell. Yes, and that is pursuant to 19 or is it 20? 60, whatever, 90, I don't remember the exact rule, but the Court of Appeal looked at the exercise of his discretion and said to you that unless you could show that there was a blatant error, egregious error in the exercise of his discretion, that the Court of Appeal would not,
Well,
as the law demands that the Court of Appeal would not.
Right.
So it's not just enough to say that,
well, if Your Lordship, Your Honor, will allow me to demonstrate how the Court of Appeal, we say, fell into error in its analysis.
Yes.
The starting point is that a decision either under Part 14, Part 15, or Part 26.3.3 A, B, or C are usually, especially the ground 26.3.3 B, which it seems as it was the one relied on by the ninth respondent to predicate their application, are not exercises of discretion. They are actually decisions of a high court judge on the merits of a claim. They go to the substantive strength or weakness of the matter before the court.
Is it possible for you to read the rule?
But the question is, Mr. Weeks, do you even need to read the rule? Because I'm looking at the Court of Appeals judgment, I have it right in front of me, and I'm looking at that limb which came closer or closest to favoring you, your chances of success on appeal. They having found that the inordinate delay, etc., they could still overcome that if you had some chance of success on appeal. And beginning at page 54, paragraph 54, which is at page 32 of the record, they deal with your chance of success, and that goes over to paragraph 66. So you need to find something in those paragraphs where you tell us, look at this error, look at this grave error here.
By the Court of Appeal.
By the Court of Appeal.
Your Honor, the grave error, as I understand the jurisprudence in this area of the law, and I'm not quite sure if your Lordship is indicating by reference to.
You are seeking to appeal the judgment of the Court of Appeal.
Yes, Your Honor.
You need to show us where in that judgment they made this grave error in holding that you had no chance of success.
So, the error into which the Court of Appeal fell was in not, or as a matter of fact, they treated to the substantive issues in the matter, in the actual claim itself, in the exact same way that his Lordship did. And the reason that this is important, Your Honor.
With the greatest of respect, you cannot get away with that.
Well,
you have to show us in relation to their determination on the chances of success.
Well, Your Honor.
Paragraphs 54 to 66, where they went wrong.
Your Honor, they went wrong, quite simply, because they ignored an entire legal principle in their analysis. There was a complete absence in their reasoning of the line of cases dealing with money lending legislation and when people breach them. They also ignored the fact, as it relates to strength or weakness, of the fact that there are two distinct, separate causes of action pleaded by the claimant, which are to a degree interrelated. And to say that.
But Mr. Weeks, the chances of success is against Justice Worrell, Mr. Justice Worrell's holding that summary judgment would be.
Was applicable.
Was applicable.
Yes, Mr.
So I'm not certain that the Court of Appeal would have to go into any analysis of the kinds of cases on illegality and so on that you've made reference. That's another matter for another day. The Court of Appeal said, and I'm grateful to my brother Dennis for pointing this out, at paragraph 54, the judge had a discretion. He exercised the discretion, and it would be very difficult for you to show that the exercise of the discretion was wrong.
Well, Your Honor, normally that is the case, where the judge has actually applied his mind to the correct law. We're saying, quite simply, that the High Court judge here and the Court of Appeal, in reviewing his opinion, ignored completely two things. One, that there's a line of cases from England, throughout the Commonwealth, Trinidad, Nigeria, and other cases from Antigua and Belize that deal specifically with the consequences of not being registered or licensed or in other ways being in dereliction of specific types of statutes. There is no analysis whatsoever by Justice Worrell or the Court of Appeal in its review of his work. And it's not to say that these cases were not put before Justice Worrell, because they were. There were 11 of them. Not a single one of those cases finds its way into Justice Worrell's analysis. Not one. He relies on 3 judgments, none of which deal with money lending or similar type legislation. So if you're talking about the erroneous exercise of a discretion, which we say this is not a discretion, we say that this is a substantive finding, even if it is a discretion, he has erred in principle. He's not applied his mind to the correct legal rule as espoused in these 11 cases that we have put before the court. And in addition to which, he concentrated only in his decision on this issue of banking business. There is another exquisitely discrete cause of action under the Financial Institutions Act, which is predicated on their admitted doing business in Barbados as lending money,
If I may,
which is a finance.
If I may interrupt, just to celebrate the cogency of the appeal that you would argue if you were arguing an appeal.
Yes, Your Honor.
No, listen to what I'm saying. If you were arguing an appeal, I think that would be a cogent argument, but you are not arguing an appeal.
Well, what I'm doing, Your Honor, is
What you're trying to
demonstrating.
do, you need to show where the Court of Appeal, in its determination,
Yes.
went badly wrong.
Well,
so that we, looking at it, looking at what they did, can say this is an egregious error of law.
Well, Your Honor, in reviewing, in embarking on its analysis as to the interest of justice and so on under the requisite CPR rule, which I know Mr. Justice Burgess has written on in another case from Barbados, one which I did as well. So there's certain analysis which the court goes through under that rule.
Can you just answer the simple question?
Yes,
What did they wrong?
They got wrong, Mr. President, the fact that they too completely ignored, and these same submissions were before them, these cases.
And what did the cases say?
These cases say that when you are dealing with a particular type of statute, such as money lending statutes, of which we submit the Financial Institutions Act is one, a statute which is by Parliament's intention designed to protect the public. When you breach that type of statute.
But with all due respect,
Well-
Mr. Weeks, if I may cut a long story short, if you look at the judgment of the Court of Appeal between paragraphs 55 and 67, the Court of Appeal embarks on quite detailed analysis of the relevant statutory provisions. And as you are well aware, it's the statutes and the interpretation of the statutes which is relevant in this case. Quite apart from whatever English decisions may say in general, or what Nigerian decisions may say in general, or what any other decision may say in general. The critical thing is the Financial Institution Act, the other relevant acts in Barbados which govern this case.
Yes.
And the court looked
No, it
at the
didn't.
relevant law.
No, it didn't, Miller. That's the point.
I'm misreading. I'm misreading paragraphs 55 to.
No, you're not
67.
misreading. You're misreading what's there. My point is, what is important is what is not there.
Okay, what is not there?
There is no analysis of one of the pleaded causes of action on the intended appellant's re-amended claim, which sets out a completely different argument, predicated on a different section of the FIA, which does not find its way in Justice Worrell's decision, the Court of Appeal's decision. They simply don't deal with it at all. And this, in our estimation, is actually the strongest of the causes of action which Sigma has put before the courts of Barbados.
And just remind us, what exactly is that cause of action?
That cause of action pleads a breach of sections 23 and 24 of the Financial Institutions Act, which basically says, or which basically say, that if you are in the business of making money from the making of loans, you must be registered under this act. Failure to do so is an offense.
Okay.
You can be imprisoned and you can be fined up to $100,000.
Does it make
Mr.
the
Weeks.
debt disappear?
Yeah.
Pardon me,
exactly.
Does it make the debt disappear? I mean, here,
Yeah, well, Your Honor,
the trees borrowed $10 million. If you are right, that means they don't have to pay anything back.
but that's the point.
Well, that's a big point.
But then our point is they owe us money.
Or just a minute, Mr. Weeks, you read what the penalties were.
Yes, Your Honor.
So fair enough to protect the public interest. You said the penalties were they could be fined or even imprisoned. One
Yes.
assumes directors.
Yes, Your Honor.
But what the president is asking is a more nuanced focus. Let us assume that they should have been registered, and let us assume that they were not.
Yes.
And let us assume that they were fined and or imprisoned in due course of time.
Yes, Your Honor.
What does that do to the loan contract between the trees and, is it KSF?
Yes, yes, Your Honor. KSF and the security taken,
Yeah, what does the legislation say about
it
that?
is silent.
Exactly.
Right.
So that even if you are right on all of this statutory remedy, which is a public policy remedy, which is to criminalize the non-conformity with the statutory requirements, i.e. be registered,
Yes.
those remedies or sanctions are a fine and imprisonment.
Well, Your Honor, this is
But this
where...
case is not about that. This case is about a debt.
Your
You
Honor.
want to reach the point eventually to say that the primary contract must be set aside. It's null and void.
Yes, Your Honor.
Well, do the cases say that?
That is exactly what the cases say, all 11 of them.
The problem for you, Mr. Weeks, is paragraph 67 of the Court of Appeals judgment. Even if SCI had shown that banking business was being conducted by KSF, KSF's involvement in banking business would not invalidate the mortgage unless the statute by construction requires that conclusion.
No, no, Your Honor, and I will come to this.
You will?
Because this case is the only case that research has thrown up. It's an Australian case, and the facts of this case are extremely distinguishable from the facts in error here.
So Weeks, I don't think you are accepting what we are trying to tell you. You are not arguing an appeal. You are arguing against what the Court of Appeal decided in terms of its determination of your prospect of success.
And yes, Your
You
Honor.
want to argue that they were wrong in this holding.
And I'm attempting to do so, Your Honor, by demonstrating to the court.
But I'm saying to you that that's what you're trying to do. You're trying to show your argument why they are wrong. But what you need to do is to say that they made an egregious error of law, not that they didn't reason it as you wanted.
Well, my lad, to ignore, and let me frame it in
To
this.
ignore
Let me
a
frame
line
it-
of authority which you say is cogent and which, had they considered it, would have led them to the directly opposite conclusion is an egregious error of law.
It is.
Yeah. So you see, I understand what you're trying to say?
Yes, Your Honor.
Yeah, okay.
And I would just wish to make the point for the record that the authority relied on by the Court of Appeal, in addition to, as a brief add-on to what I've just said, this case, while an interesting case, was a case in which a bank, an established licensed bank,
But Mr. Weeks, Mr. Weeks, sorry, I don't mean to interrupt you. Really don't. I don't really want to. But look at paragraph 55 of the judgment of the Court of Appeal. Look at paragraph 56, where the court looks into banking business and looking to see whether the bank was carrying on banking business. Look at paragraph 57. Worrell just stated at paragraph 9 in his decision that he could find no affidavit evidence in support of SCI's application, which would suggest, and so on. In other words, if there's a fault, it would seem to be with SCI in not providing the requisite affidavit evidence. It goes on. It goes on and deals with the law as the law applies in Barbados. That's the Financial Institutions Act. Innocent of any discussion of cases which may or may not be relevant. So if you latch on to Yango, which is a case which is known by everyone who looks at illegality in a banking institution situation. That doesn't take us very far. And in any case, Mr. Weeks, and this is, I think, to help us to move forward, that is only one consideration. The question as to whether there's a chance of success of the appeal. That's only one consideration in deciding whether the interest of justice would mean that you should have been given an extension of time.
Well, I'm going to get to those other branches because I know what needs to be established properly. So I'm going to get there because, and Your Honor is really quite correct. There's only one. I started there. There's another one which you must demonstrate. There's a case from the Court of Appeal of Barbados, which His Honor wrote the decision on extending time, in which, in circumstances not dissimilar to this one, where you must demonstrate a significant public interest in the issues being raised by the particular case. In that particular case, before it was a constitutional matter.
No, that was,
in this case,
sorry, if I may, that was based on a completely different provision.
No, it's the exact same one.
Sorry.
Because I was out of time even to file under the previous paragraph.
Perhaps we shouldn't argue. What do you have the rules with you?
I do indeed. Do you have CPR rules?
Yeah, the rules under which you applied or should have applied, or is,
and I did apply,
understood to have applied, is Rule 62.12. That's the rule under which you should have applied.
But there are two applications possible under that paragraph, and I'll direct your lordship to the exact one which we made.
If I may, Mr. Weeks, the Eiffel case to which you are referring is a case which is decided under 62.6, 2, and 3 of CPR. And the conditions which are laid down in 62.6 are very different from the conditions which are laid down in 62.12. You have the rule? Could you read 62.12? So Eiffel is not relevant to this case. Consumer guarantee is a case which deals.
Could you find our actual application for the No, our application in the Court of Appeal. I crave the Court's indulgence because I think it's worth.
You're still 2 minutes within the maximum time allotted to you, so.
I don't think the chairman was referring to the 15 minutes.
No. I'm trying my best to get there, Your Honors.
I think you're heading to the hour. That's what he was telling you.
Could you find where it's actually? The rule, Your Honor, my understanding of what we argued before the Court of Appeal, it was always the intention that sub-rule 3, where it was the overarching jurisdiction in the interest of justice, which was being triggered.
But it couldn't be that rule. It couldn't be that rule because 62.6 deals with a situation where you are seeking an extension of time to file an appeal. Section,
no, I think we're talking across purposes.
Yes, what you were seeking, as I understand it, is leave. You wanted the court to give you an extension of time to file leave to appeal, not to file an appeal, but to file leave to appeal.
Exactly.
Now, there's no rule. No special rule in our CPR, in the CPR of Barbados, which allows that. There is, however, a rule in Part 62.21, which gives the court a general power to disregard or not enforce rules. What the court decided in consumer guarantee was that this general rule would be utilized by the court to allow the court in proper cases to extend time for filing applications, to extend time to file leave to appeal, leave to obtain leave to appeal before the court?
But
I think we have to close off now. So, if there's some final thing you want to say, you have 1 or 2 minutes.
Your Honor, simply this. This court is being asked to essentially correct what we are submitting are a series of errors which found its way into the decision of the Court of Appeal in this matter. And in the interest of justice, this court ought to, we submit, uphold our application for special leave and to hear our appeal, because the issues raised by this case.
Which appeal? Which appeal do we have to hear? Because
The application which is before this court is for special leave to, we say, overturn the decision of the Court of Appeal not to grant us leave to argue an appeal before the Court of Appeal on the merits.
Okay.
And the reason we say that, and the reason we have come to this court, is that the issues raised by this case are very, very substantial, important matters.
I think we understand that, Mr. Biggs. What I think the President is trying to get at is, if we were to accede to your request, what would happen in practical terms?
In practical terms,
yes.
If this court granted leave, heard our appeal, agreed with our position, it would remit the matter back to the Court of Appeal for the Court of Appeal to hear our application or appeal on the merits.
No, what are they going to hear? Your application or your appeal? Because they are very different things. The application before the Court of Appeal is to give you additional time.
Yes.
To submit your application for leave.
Well, to give us the opportunity which they deprived us in the Court of Appeal.
Correct. So that's what you want us to do, send it back to the Court of Appeal to ask them to do that.
Indeed. That would be, strictly speaking, what the court would be asked to do, and the only thing that the court could really be asked to do here, and to give, essentially, to give Sigma the legitimate opportunity to pursue its actual substantive case on the basis that I've attempted to put before the court, on which we have in our written submissions.
Good.
Okay, clear.
Thank you.
Thank you.
So, Mr. Patterson.
Yes, Your Honor.
And may I say,
I
Mr. Patterson, that I suspect the President's suggestion to your friend who spoke before, that maybe this could be limited to 15 minutes, would equally apply in your case. I'm sorry?
It can be less than that.
Oh, my goodness. Wonderful.
Good. You can proceed then.
This case, on the assumption that this is an application for this court to grant special leave to appeal the decision of the Court of Appeal when it refused the applicant permission to file an application for leave to appeal, on the assumption that that is what this is about. This case falls within...
Go ahead. Yes.
Yeah.
Please go ahead, sir.
This case falls within the principles outlined in Lane and Esdale, which were adumbrated in this court's decision in Mohan and Persad, which I will simply summarize at paragraph 18 of that decision, Mohan and Persad. The court said, Section 8 of the CCJ Act, giving effect to Article 15.4 of the agreement, is in equally broad terms, reserves an unlimited residual discretion to prevent miscarriages of justice. It permits applications for special leave to the CCJ from any decision of the Court of Appeal, even if it is not possible for such a decision to proceed on appeal to the CCJ via Section 6 or 7, whether based on earlier rulings or ruling in the case in question. The words "any decision" comfortably embrace a refusal of the Court of Appeal of leave to appeal to itself out of time, and that the principle that applies in such cases is that the special leave will be given in exceptional circumstances to prevent a miscarriage of justice. So that's the standard that must be satisfied for the purposes of this application for special leave. It is incumbent on the applicant to demonstrate not just that there was an error, but that there would be, unless the special leave is granted, a miscarriage of justice. Now, let's bear in mind that what was before the Court of Appeal was an invitation for that court to exercise an exceptional jurisdiction. His Honor, Mr. Burgess, said those words in the CGI case, that the jurisdiction under CPR 62.12 is an exceptional jurisdiction, not just an ordinary invitation to exercise a discretion, but to exercise a discretion exceptionally, so that the bar is exceedingly high to satisfy a court under 62.12 that exceptional jurisdiction should be granted, and the principles on which that jurisdiction would be exercised were outlined by the court in CGI and adopted by the Court of Appeal in this case at paragraphs 40 and onwards. So that when this application for special leave is made, it is made in the context that the court, in the exercise of its exceptional jurisdiction, said no. So that you don't have an appeal, you don't have leave to appeal. What you're appealing, what you're asking this court, the CCJ, to do is to interfere with the refusal of permission to file an application seeking leave to appeal. Twice removed. And the Lane and Esdale principle says that the court ordinarily, the Court of Appeal, ordinarily has no jurisdiction to entertain any such appeal where it relates to the refusal of permission to file an appeal. This court in Mohan and Prasad said, notwithstanding Lane and Esdale, it can intervene if there is a clear miscarriage of justice. The words egregious error of law were also used in other authorities. But in the cases where you are seeking special leave to appeal against a decision which refused permission to appeal out of time, this court said the standard is satisfying it that there would otherwise be a miscarriage of justice unless leave is granted. Now, I've struggled to understand my learned friend's case. I struggled in the court below, and I'm struggling here to understand what that case is. What exactly is the error? At best, what I've gleaned is that he's saying he disagrees with the assessment of both Worrell J in the exercise of his discretion and the assessment of the Court of Appeal in considering the prospects of success. And he's inviting this court to substitute its own decision as to those prospects, which is the very thing that it cannot do when looking at the exercise of a discretion, because ultimately the jurisdiction on a 62.12 is conferring a discretion on the Court of Appeal.
So this is about a triple discretion.
It's a triple discretion. And so the bar is exceedingly high. You have to show not just that he got it wrong, not just that his assessment of prospects were wrong, but that unless this court intervenes, there will be a miscarriage of justice. And I just want to talk about the miscarriage of justice for 1 second, and then I'll wrap up. Because when you remove all the fluff in this case, what is it about? What was the underlying case about? KSF loaned money to Trees, got a mortgage, the money wasn't repaid. This applicant got a judgment against Trees, in due course got a charge in order to secure that judgment, and is now seeking essentially to jump ahead in the line, jump ahead of the KSF mortgage. And the only way that it seeks to jump ahead is to say, well, let me attack the validity of that mortgage. Let me also attack the validity of the assignment to Ram Holdings. We said in the court below and in the High Court, we said, I don't even know what cause of action is disclosed against KSF. This applicant is not privy to the arrangements between Trees and KSF. They had nothing to do with this underlying contract, yet here we are in court, being a defendant, where this busybody who is motivated by the objective of jumping the queue seeks to attack a contract which had nothing to do with him.
You mean the assignment?
No, the mortgage.
You mean between KSF and Trees?
And Trees. His initial attack is against the mortgage. He's also attacking the assignment.
Can I ask you a question?
Yes,
This
sir.
line of cases that Mr. Weeks has told us about, 11 cases, is it correct that those cases say that in similar financial institution legislation, that beyond a fine or imprisonment, the a consequential loan or mortgage can be set aside as invalid?
Those cases are money lending cases, cases decided under the English Money Lending Acts, where the specific contracts under those legislation were prohibited. The case law on illegality says that where the statute prohibits the entry into of a contract, the illegality will taint the validity of the contract. Here, it is not a money lending statute that we are dealing with. We are dealing with that establishes financial institutions.
So the problem here
To call a
is
bank-
a failure to register, not a prohibition on the lending of money.
It is not.
This is a different.
No, it's not a prohibition. It's a different category, and that's why the case of Yango is important. Because the case of Yango is on all fours with this case. The case of Yango involved similar legislation, not money lending legislation, but financial institutions legislation, the Banking Act. Our Financial Institutions Act is a successor to the Banking Act. It's the same legislation. And so the comparable legislation is the Banking Act that was discussed in Yango. And in Yango, what the court said in Yango was simply the legislation seeks to prohibit conduct, not the contract. It seeks to prohibit the carrying on of banking business without a license. It doesn't address the contract. The word contract isn't mentioned at all. There is no piece of that legislation, the Financial Institutions Act, that prohibits the entering into contracts when you are not licensed as a financial institution. And so the decision in Yango said very decisively that the failure to obtain a license under the relevant banking legislation in Australia did not invalidate the underlying mortgage.
Okay.
And that's the case that we're saying here. It's exactly on point.
Yeah.
And the Court of Appeal...
One
Yes.
question, because I'm reading in the judgment of the Court of Appeal, paragraph 6, appended to the loan was a letter dated 3rd of October 2006 from the Central Bank of Barbados, which, so far as relevant stated, we refer to previous correspondence ending with your letter dated August 10, 2006, seeking permission for a loan of 10 million from KSF to the trees. We advise that approval is granted for the trees to borrow 10 million from KSF. So that is correct. That was a letter sent from
Central Bank.
From the central bank to KSF or to the trees?
That's exchange control permission, which really doesn't arise in this case. That's a letter giving permission, exchange control permission.
I see.
So the issue of exchange control permission doesn't arise in this case. The issue that was before the court was whether or not the failure, assuming that there was an obligation to obtain a banking license to grant loans, whether the failure to get the banking license
Would render the contract
invalidated the underlying loan security. That's correct.
Yeah.
And we say
Can I ask
that
one, Mr. Patterson?
when you look...
Can I ask one question? Did the Court of Appeal, in its decision, refer to Yango? Did it refer to...
Yes,
it did, right?
Yes.
Paragraph 57.
Yeah, paragraph 57.
Paragraph 57.
I wouldn't want you to think that, Mr. Patterson, that this court doesn't notice differences between the Australian relevant legislation and the Financial Institutions Act in Barbados. And even though you may want to rely on Yango, another view may very well be that Yango isn't relevant to the legislation in Barbados. But that's for another time. That matter doesn't arise in what is before us. But I just wanted to underline that, yes, we are aware of Yango and your views on Yango, but your views may not be shared universally by lawyers in Barbados or the court in Barbados. Be that as it may, I think that you're addressing the right questions, and I'm just suggesting that you may not want to put too much reliance on Yango.
Well, I think the reference to Yango was simply to say that you have to contrast the money lending line of cases with the cases decided under similar legislation to our Financial Institutions Act. The money lending cases are a special species of themselves. We have no equivalent legislation in Barbados, such as the money lending statutes in the UK. And those statutes were aimed at preventing the contracts, the evil that was aimed at was the entering into of money lending contracts without complying with the requirements of those money lending statutes.
Yes, I think you're right,
So
Mr.
the
Patterson.
contract,
Sorry. Mr. Patterson, I think you're right. There's no need to go any further on that. I was just making the point that in relation to whether contracts are rendered illegal for non-registration by financial institutions not registering under the FIA, that question has to be determined on a proper interpretation of the FIA and not on an application of Yango. That's the only point which I'm making to you. But beyond that, I think that the points you've made are, I understand the points which you've made.
how much you beg?
Okay, Mr. Patterson, that was it, or?
Unless well, I was just going to wrap up to say
Yes.
that I'm yet to understand whether where my learned friend says there will be a miscarriage of justice. I don't see that when one takes a step back and look at the circumstances, that my learned friend could properly say that there would be a miscarriage of justice unless this court intervened. I'm not sure that my learned friend has established even that the Court of Appeal got it wrong, much less that it got it wrong in such a way that there would be a miscarriage of justice. And with those comments, my lords, unless there is anything else I can assist on.
No, thank you.
Much obliged.
Mr. Alert?
Your Honors, if I may start at the stigma's notice of application and what it's set out at paragraph 1 of that application, and point out that the inconsistency with what was decided at paragraphs 71 to 73 of the Court of Appeals decision. It is clear that in the Court of Appeals was dealing with a procedural issue of leave, but it appears that Sigma wishes to go beyond that. If I may, Your Honors, move to the factual and legal context in which this application was made. On the 9th of October, Sigma filed its re-amended claim form and re-amended statement of claim. In the re-amended statement of claim, it sought 9 declarations, 6 in the affirmative, as I put it, and 3 in the alternative. And on the 10th of October, the next day, it then filed its application for summary judgment. In that summary judgment application, it sought summary judgment against all 9 defendants, but it sought summary judgment on only 4 of the affirmative declarations. That factual context therefore reveals that Sigma knew, or ought to have known, by the summary judgment application alone, whether on the application or any order made on that application, its entire action would not have been brought to an end.
Counsel, are you arguing the interlocutory point?
I'm arguing that the Court of Appeal was correct that leave was required.
Yeah, but
And
Counsel, I asked that because I thought that however much Mr. Weeks wanted to qualify or gloss on it, he conceded that that appeal is not any longer extant.
Yes.
Very well, my lord.
Therefore, I don't know why you need to argue this.
Is there anything left for you to argue?
Just that we are now 3 years on from the High Court's decision with this application. And therefore, whether or not Sigma establishes a special feature that granting leave may well operate injustice to others. And in dealing with the case justly, it ought not to be confined only to stigma, but to all of the parties concerned.
Okay.
Thank you.
I can leave it there, my lord.
You okay?
Thank you. Mr. Weeks.
I take it, my lords, that my reply is going to be very brief and only on one point of law.
Okay.
The section that the Court of Appeal was operating under was 62, was it? I just had it. Anyway, it speaks of special reasons. So the use of the words miscarriage of justice, public purpose, and all of these are attempts to divine what is meant by special reasons. In this case, those special reasons, despite what my learned friend has submitted on the law, are that this case concerns financial institutions in Barbados, the regulation of financial institutions, those who would lend money as a business, and to have a situation where the lending of money as a business goes completely unregulated cannot be countenanced at all. And therefore, in looking at this case, the public importance does form, in our humble submission, sufficient special reasons for the Court of Appeal to have treated correctly to the substantive issues as a part of its analysis. It erred in that respect, and therefore we say that the position which has been put forward on the law by my learned friend for KSF is not the correct position. His position, as I understood it, as he was making his submissions, is that the money lending legislation in the UK, the money lending legislation in Trinidad, because two of the cases which we put before the court on that issue were Trinidadian cases, and there are also cases dealing with banking legislation in Antigua and in Belize. So that to say that the law, as it relates to the consequences of doing things or taking actions in breach of such legislation, cannot be so easily sidestepped in any analysis of these issues. Because the money lending legislation, as far as I'm aware, we have never had formal money lending legislation in Barbados. We have always had banking legislation. The financial institutions legislation currently in force is an up-to-date version of the statutes which have governed banking. So that to say that the money lending legislation, which is the subject of many of the cases which we've put before the courts, and the Financial Institutions Act are in some way of a different breed of statute, we say is simply not a tenable legal submission because they cover the same ground. They deal with the lending of money.
Sorry.
So that, I'm just saying,
Sorry.
Your Honor.
Sorry.
I'm going.
Yes. I couldn't allow you to make those statements without saying that they do not bear legal analysis. The Banking Act is very, very, very different from money lending legislation, which is much older than the Banking Act. And the purpose of the money lending legislation is a very different purpose from the Banking Act. So that the money lending cases, and there are numerous money lending cases which have been decided over the years in relation to illegality. So I don't think that you're correct.
Well,
I'll try not to interrupt again, but I couldn't sit by and allow you to say that the money lending legislation is in pari materia or similar to the banking legislation.
They are dealing with the same.
But they're not.
The regulation of money lending is an important public purpose. Whether it is named a Money Lending Act or an act which says you do not lend money unless you apply for a license, are vetted, and comply with certain very strict conditions, it doesn't matter if an act, with great respect to the court, is called a Money Lending Act or the Financial Institutions Act. The purpose is the same. It is to protect the public from dealing with people who are unsavory, who would be up to no good, and who may very well even be dangerous. The purpose of the legislation is the same, which led to the common law rule that if you breach that legislation, even when there are stated consequences, the case of Patience from Nigeria specifically deals with that issue, to say that is for Parliament. They can say whatever they like about the penalties, but that doesn't limit the common law's ability to say that when you breach these acts, it renders them either expressly illegal or impliedly illegal and are completely unenforceable.
We follow
so
you,
on
Mr. Weeks.
those brief comments, my lords, your honours, I just thought I would attempt to correct what I thought was a position put forward on the law, which I don't think is correct by my learned friend. And with those comments, I would close the submissions.
Thank you very much. I think we will withdraw briefly to see if we can reach a decision or whether we want to reserve for a further deliberation and decision. So we withdraw, but you can expect us back soon.
All rise. Of the Caribbean Court of Justice.
Take your seats.
Yes. The court has reached a decision in this case. Mr. Weeks, despite your industry and passion, we don't think that of course the mountain was very steep to climb, and we are afraid that you were not able to get to the top and get over it. So we will refuse the application for special leave. We will give brief reasons later on. Costs for the defendants to be taxed if not agreed. I think Justice Barrow would want to make one or two remarks about that point.
A very brief observation in relation to the matter of costs on a special leave application. There were proceedings earlier this week in which the same question arose, and we directed attention to Rule 18.33 of our rules, which speaks as to the quantum of costs which may be awarded on a special leave application when the special leave application is treated as the hearing of the appeal. And the indication seems to be, looking at 18.33, that the amount of costs would be limited to a figure in a basic cost schedule, and that figure would be $8,000 for the entire appeal. And this, as I say, is when the special leave application is treated as the hearing of the appeal. It seems to me that if that premise is correct, then the costs on a special leave application not treated as a hearing of the appeal would be lesser. I mention this to urge parties to have a reference to what the rules provide, and I think save time by agreeing as to costs. We are not fixing it because we have not heard argument in relation to the quantum, but we urge parties or counsel to have regard to what is mentioned and agree costs. Thank you.
Thank you very much. Okay.
All rise.